Picture a massive textile mill in Bombay, right at the turn of the 20th century.
Oh, yeah. The noise alone would be completely deafening.
Exactly. You've got these massive belts spinning at thousands of revolutions per minute, unventilated air just thick with cotton dust.
A literal pressure cooker.
Right. And a worker who's probably exhausted after a 14-hour shift misjudges a movement by like half an inch. A hand gets caught in a loom.
Which happened all the time, sadly.
All the time. And in an instant, that worker loses their livelihood, their identity as a provider, and, very likely their life, given the medical care back then.
Yeah, infection was practically a guarantee.
So the truly terrifying question isn't just about the medical emergency. The terrifying question is, what happens to their family the very next morning?
Total destitution.
Mm-hmm.
I mean, that was the reality. There was absolutely no safety net, no HR department, no severance package.
Nothing.
Nothing. The machinery of industry was advancing at lightning speed, but the legal architecture to protect the fragile human bodies operating those machines simply did not exist yet.
And bridging that gap between the inherent dangers of going to work and the survival of the human beings doing the labor is one of the most brutal, fascinating, and vital legal evolutions in history.
It really is. It's the foundation of modern labor law.
So if you are a law student, maybe you're gearing up for your Osmania University LLB exams, and you are staring down the barrel of Unit 3rd on Indian labor law.
A dense unit, for sure.
Very dense. Or, if you are a legal professional dealing with compliance, or even if you're just insanely curious about the invisible safety nets strung beneath our modern economy, today's deep dive is your ultimate cheat sheet.
We're getting into the weeds today.
We are. We're unpacking the massive, century-long legal effort to put a price on human risk and create what we now legally call Social Security.
Because it's an evolution that tells you everything about what a society actually values. The legal frameworks we are diving into today, like the Employees Compensation Act of 1923, the massive Employee State Insurance Act of 1948, all the way up to the modern 2020 labor codes.
Right.
They aren't just dry statutes. They are treaties, basically. They represent the negotiated settlement between capital, labor, and the state.
Okay, let's unpack this. Because to understand where we are today, we really have to understand the void that existed before these laws.
The absolute 0 point.
Yeah. When we talk about Social Security in a legal context, the sources define it broadly as state-legislated measures to maintain a person's income when they're hit by sickness, disability, unemployment, or old age.
Right. It's the ultimate backup plan.
But for centuries in India, the state didn't actually need to legislate this.
No, because the primary social safety net was deeply cultural. It was the agrarian joint family system.
Which worked pretty well for what it was, right?
It did. If you were working in a village in, say, the 1850s, and a bullock cart ran over your leg, you didn't need a government pension.
You just went home.
Exactly.
Well,
Your extended family absorbed the economic shock. Your brother plowed your field, your aunt took care of your kids, your cousin fixed your roof. The risk was pooled informally through bloodlines and community ties.
But then the Industrial Revolution happens and just shatters that completely.
It completely obliterates it.
Yeah.
You have massive rural to urban migration. Millions of people leaving those tight village networks to work in factories in Calcutta, Bombay, and Madras.
Living in these incredibly crowded tenements.
Right, as nuclear families or even just single individuals.
Yeah.
So that traditional safety net just vanishes. When that worker's hand gets caught in the loom in 1910, there is no brother down the street to plow the field.
There is just immediate starvation.
Exactly. Immediate crushing poverty.
So the state is basically forced to step in and artificially construct the safety net that the family used to provide. And I found it fascinating in the sources that this wasn't an isolated Indian phenomenon.
Oh, not at all.
The formal state-sponsored concept of Social Security actually started in Germany, right? In the 1880s under Otto von Bismarck.
Yes, and Bismarck's motivations were highly, highly pragmatic.
He wasn't just being a nice guy.
Not even a little bit. He wasn't being benevolent. He was trying to stave off social step risings. He looked around and realized that if the state didn't provide a basic floor of existence for injured and elderly workers, those workers would eventually just burn the state to the ground.
A survival tactic for the government itself.
Precisely. So he instituted the first mandatory sickness and accident insurance programs. And the idea was simple, but completely revolutionary for the time. Specific trades like miners, weavers, blacksmiths were legally required to contribute a tiny fraction of their wages into a shared pool.
And the employers had to match it, right?
Yes, matched by their employers. It's the birth of formal legislated mutual aid.
So fast forward to post-independence India, and the framers of the Constitution realize they have to hardwire this Bismarckian concept into the very DNA of the new republic.
They absolutely had to.
Article 41 of the Constitution, which sits right there in the directive principles of state policy, makes this incredibly explicit.
Article 41 is basically the philosophical anchor for everything we are going to discuss today. It directs the state to make effective provision for securing the right to work, to education, and critically, to public assistance in cases of unemployment, old age, sickness, and disablement.
It's basically saying, hey, political freedom means very little if you are starving because you got sick.
Exactly. What good is a vote if you can't feed your kids? And this aligned India with emerging global standards at the time, specifically the International Labor Organization's Convention number 102.
ILO Convention 102.
Right. That convention laid out the bedrock minimum standards of Social Security for the modern world. India was hooking into that global framework.
Now, within this massive project of Social Security, the legal architecture provided in our Unit 3 syllabus splits into two very distinct mechanisms.
Yes, a crucial distinction.
And I want to make sure the mechanics of these are crystal clear for you listening because they function entirely differently. You have social insurance and you have social assistance.
Right.
Is social insurance basically like an enforced massive subscription model for life's worst-case scenarios, while social assistance is a pure safety net?
That is exactly the right analogy. For social insurance, the operative word is contributory.
Meaning you have to pay to play.
Precisely. The Employees State Insurance Act, the ESI Act, and the Employees Provident Funds Act, the EPF, are the prime examples here. You mentioned a subscription model, and actuarially speaking, that's precisely what it is.
Because it relies on the law of large numbers.
Yes. If you have 10 million workers paying a small percentage of their wages into a fund every single month, and the employer's matching or even exceeding that contribution, you build a massive reservoir of capital.
And only a tiny fraction of those 10 million workers will actually suffer a catastrophic injury or illness in any given year.
Right. So the healthy subsidize the sick. The lucky subsidize the unlucky.
And because they paid into it, it's not a handout.
That is a vital point. It is not charity. It's a purchased legal right. Because the worker contributed, they have a legally enforceable right to claim from that fund when they need it. The Supreme Court of India actually validated this entire model in cases like Bridge and Roof Co. India, LTDV Union of India.
What did they say in that case?
They affirmed that compulsory contribution schemes, like the EPF, are entirely constitutional because they are vital mechanisms for long-term financial security. The state has the right to force you to save for your own disaster.
Okay, so if social insurance is the toll road where you pay your premium to get the benefits, social assistance is the public highway.
Yeah.
It is a pure safety net for the most desperate.
Yes, social assistance is strictly non-contributory. It is funded entirely from the general tax revenues of the state.
So no deductions from a paycheck.
Right, because this is designed for incredibly vulnerable populations who are living below the poverty line. People who literally cannot afford to give up even 1% of their daily wages to an insurance pool because they need that 1% just to buy rice today.
The National Social Assistance Program, or NFAP, is the umbrella for this. But what strikes me from the sources is that it's not just a blanket basic income.
No, it's very targeted.
Right. The state doesn't just hand out checks to anyone who is poor. It categorizes the vulnerability very specifically.
Because state resources are scarce. The state has to target the demographics that are statistically the most likely to face absolute ruin.
Give me some examples from the text.
Well, look at the specific schemes under the NSAP.
Yeah.
You have the Indira Gandhi National Old Age Pension Scheme, IGNO APS. That's for those 60 and above who are below the poverty line.
Okay, makes sense.
Then you have the Indira Gandhi National Disability Pension Scheme for persons with severe multiple disabilities. And then there's the Indira Gandhi National Widow Pension Scheme, which specifically targets widows aged 40 and above.
Wait, hold on. Why specifically age 40?
It seems arbitrary, right?
Yeah. Why wouldn't a 30-year-old widow receive the same assistance? She's just as widowed.
It comes down to really grim demographic and labor market realities. The state calculates that a younger widow might, theoretically, have a higher statistical chance of remarrying, or she might be physically more able to enter the manual labor force to sustain herself.
Oh, wow. Okay.
But a widow aged 40 or above, particularly in impoverished rural areas, faces immense cultural and physical barriers to finding gainful employment, especially if she has never formally worked outside the home before.
The labor market just won't absorb her.
Exactly. The scheme is surgically targeting the intersection of age, gender, and poverty, where destitution is almost guaranteed without state intervention.
That makes the underlying economic logic so clear, even if it feels a bit cold.
Law often is.
So, social assistance catches the most vulnerable across the general population, and social insurance creates a pooled fund for the working class. But what happens when the injury isn't just a random act of fate? Like, what happens when a worker's body is broken by the job itself?
That is where we leave the realm of general welfare and enter the fierce adversarial arena of workplace injury law.
The battleground.
The absolute battleground. And the cornerstone of this in India is the Employees' Compensation Act of 1923.
Formerly known as the Workmen's Compensation Act.
Correct.
This is a century-old piece of legislation forged while India was still under British rule. And it fundamentally rewrote the relationship between an employer and an employee. To understand why it's so revolutionary, we have to look at what the legal landscape looked like in 1922, the year before it passed.
The landscape in 1922 was a nightmare for the worker, honestly. Yeah. Before this act, if you were injured on the job, your only recourse was to file a civil lawsuit under general tort law.
Which means you had to prove the employer was at fault. You had to prove negligence.
Exactly. And the burden of proof was entirely on the injured, often destitute worker. Imagine an illiterate coal miner whose leg has been crushed in a cave-in trying to hire a lawyer to prove that a massive mining corporation failed to maintain proper safety standards.
It's an insurmountable David and Goliath scenario.
Utterly insurmountable. And furthermore, employers used a trio of brutal common law defenses to just crush these lawsuits before they even got to a jury.
What were they?
First, you had contributory negligence. If the employer could prove the worker was even 5% responsible for the accident, maybe they were standing an inch too close to the machine or looked away for a second, the employer paid absolutely nothing.
Wow. Any fault at all negated the claim.
Yep. Second was the fellow servant rule. If another worker caused the accident by mistake, the employer would just shrug and argue, sue your coworker, don't sue me.
Knowing full well the coworker has no money to sue for.
Exactly. It was a brilliant, evil loophole. And third, the defense of assumption of risk. The employer would argue that by taking the dangerous job in the first place, the worker implicitly accepted the possibility of getting maimed. You knew the mine was dangerous when you walked in.
So the worker was effectively boxed out of any compensation whatsoever. The entire legal system was rigged to protect industrial capital at the expense of human life.
Completely rigged. So the 1923 Act was the sledgehammer that smashed that system to pieces. It introduced a legal concept that was earth-shattering at the time: strict liability or absolute liability.
Let's look at Section 3 of the Act because this is where the magic happens. Employer's liability for compensation?
Right. Section 3 strips away the need to prove fault entirely. Under Section 3, it does not matter if the employer was an absolute angel who ran the safest factory on the planet.
Even if the machine was brand new and perfectly maintained?
Doesn't matter. If the injury happens under the right conditions, the employer pays. Full stop. The philosophical shift here is just profound.
It's saying that injuries are just an inevitable statistical reality of mass production.
Yes. The law declares that the inevitable cost of broken human bodies is simply a cost of doing business. Just as an employer pays for broken machinery or spoiled raw materials, they must pay for broken labor. They profit from the enterprise, therefore they bear the risk of the enterprise.
It transitions from a fault-based system to a relationship-based system, which is huge.
Massive.
But before we get to the right conditions that trigger this payout, the Act spends a lot of time defining who exactly is in this relationship. Because, words matter in law. Who is an employer, who is an employee, and who is a dependent?
Because in law, a definition is a fortress. It dictates exactly who gets the money and who pays it. Let's look at the definition of employer under the 1923 Act. The drafters knew that corporations are absolute masters of evasion.
Oh, for sure. If they just defined employer as the person who owns the factory, companies would immediately set up shell corporations or use middlemen to dodge liability.
Exactly. Oh, I don't employ him, my subsidiary's vendor does. So how did they close that loophole? By making the definition incredibly expansive.
How expansive?
Well, employer explicitly includes any managing agent of an employer. Crucially, it includes the legal representatives of a deceased employer.
Wait, so if the factory owner dies the day after the worker gets injured?
The liability doesn't vanish. It attaches to the dead owner's estate.
Wow, they're not letting anyone off the hook.
Not at all. And most importantly, it covers contractors. This is huge. If a massive principal employer, say, a huge real estate construction firm, hires a tiny fly-by-night subcontractor to do the really dangerous scaffolding work, and a worker falls.
The big firm can't just point fingers at the tiny subcontractor.
Nope. The principal employer cannot wash their hands of it. The law says you initiated a work for your profit, you are liable.
They cast a massive net to ensure someone with deep pockets is left holding the bag.
Precisely. But then when you flip to the definition of dependent, the people who actually receive the compensation if the worker is killed, the net shrinks dramatically.
It becomes very rigid.
Highly categorized.
Yeah.
A dependent includes a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother.
But wait, what if the worker was unmarried and lived with his adult brother who relied on him for rent? Why isn't the brother automatically a dependent? Why is the list so incredibly strict?
Because a massive payout creates a target. The 1923 Act is designed to prevent absolute destitution for those who were strictly biologically and legally reliant on the deceased worker's income.
Right.
If a worker dies and there's a lump sum of, say, 5 lakh rupees suddenly available, distant relatives, opportunistic uncles, or casual acquaintances might swoop in, claiming they were dependents.
Everyone wants a piece of the pie.
Exactly. By keeping the categories rigid, the law builds a protective wall around the most vulnerable, the widow and the orphan children, ensuring the money goes exactly where the survival need is highest.
Okay, so we know who pays and we know who receives, but what triggers the payment? You mentioned earlier that the employer pays if the injury happens under the right conditions.
Right.
Because if a worker gets injured playing cricket on Sunday, the employer obviously isn't liable. The magical incantation in the law, the absolute hinge upon which this entire century-old act swings, is that the injury must arise out of and in the course of employment.
Yes. Out of and in the course of. It sounds like one seamless phrase when you read it, but it's fundamentally a dual requirement. It's a two-pronged test, and the worker must satisfy both prongs to unlock the employer's absolute liability.
Let's break them apart for the listener, because this is definitely going to be on the LLB exam.
Oh, guaranteed. Okay. Prong 1. In the course of employment. This is primarily a chronological and geographical test. It asks about time and place.
Were you on the clock?
Exactly. Did the accident occur during the employee's designated working hours? Did it happen on the factory premises or at a specific location where the employer sent them to perform a task?
It establishes the perimeter, the boundaries of the job.
Right. Now, prong 2, arising out of employment. This is a causal test. Is there a direct, unbroken chain of causation between the duties the worker was hired to perform and the accident that injured them?
Did the job cause the injury?
Yes. Did the inherent nature of the work expose them to that specific hazard?
So let me test this. If I'm at my desk in an office building during work hours, so I'm satisfying the time and place of in the course of, but a disgruntled ex-partner of mine sneaks into the building and assaults me over a personal dispute.
A terrible situation, but...
That injury did not arise out of my employment, right?
Right.
My job duties didn't cause the assault.
Exactly. The causal link is broken. The employer isn't liable for your personal disputes just because they happen to culminate on company property. Both the temporal and the causal nexus must exist simultaneously.
But work isn't always that clean. People don't just teleport into their cubicles or onto the factory floor. They commute. They take breaks. They run errands for the boss.
And that is where the law has to get really creative. Which brings us to one of the most intellectually fascinating doctrines we are covering today, the principle of notional extension.
Notional extension. I love this concept.
It's brilliant jurisprudence. Notional extension is the courts recognizing that the physical iron gates of a factory are an arbitrary boundary. The reality of employment extends beyond that perimeter fence.
So the doctrine artificially stretches the definition of in the course of employment.
Yes, to cover activities and geographies that are reasonably incidental to the job.
How far does it stretch? Let's look at the bicycle case mentioned in the text.
Ah, classic example.
A worker gets on his bicycle in the morning to ride to the factory. He's a mile away. He gets hit by a truck and loses his right leg. Now, riding a bicycle is not the job he was hired to do. He's not on company property. He's not even technically on the clock yet. How on earth can the employer be held absolutely liable for a random traffic accident?
The employer's lawyers certainly argued that they shouldn't be, but the court applied notional extension. And the reasoning is just brilliant in its pragmatism. The court dictates that the journey to the workplace is an absolute, unavoidable prerequisite to performing the labor that enriches the employer.
You can't do the work if you don't get there.
Exactly. The worker isn't on the road for leisure. They're on the road because the employer demanded their physical presence at a specific place at a specific time. Therefore, the journey is reasonably incidental to the employment. The risks of that journey are subsumed into the risks of the job.
That is a massive expansion of corporate liability.
It is, and the Supreme Court really cemented this in landmark rulings. Take the Dulapai case, Dulapai versus Employers Liability Assurance Corporation, Ltd.
What happened there?
A workman was literally just on his way to the workplace when he suffered a fatal accident. The Supreme Court ruled unequivocally that the strict liability applies. The moment the worker initiates the journey specifically for the purpose of fulfilling their employment contract, the protective umbrella of the 1923 Act opens over them.
And there was another case, right? Bhavnagar Municipal Corporation.
Yes, Bhavnagar Municipal Corporation versus Panubin Nanapai. It echoes the exact same principle, applying strict liability when a casual worker died while performing incidental work. The nexus is proven because the activity serves the ultimate purpose of the employment.
Okay, I follow the logic. If the journey serves the employer bears the risk of the journey. But I have to challenge the limits of this strict liability.
Go for it.
Let's talk about human stupidity. Let's talk about recklessness. What if the employer does everything right, provides a perfectly safe environment, and the employee is just acting like a fool?
You're talking about contributory negligence creeping back in.
Right. There is a specific case study in the sources that highlights this perfectly. An employer buys expensive, specialized safety spectacles for a worker. The supervisor hands them to the worker and explicitly says, "Do not operate this grinder without these glasses."
A very clear instruction.
The worker decides the glasses are annoying, leaves them on the bench, turns on the grinder, a shard of metal flies up, and the worker completely loses his eyesight. Now the employer argues, "We spent money to protect him. We gave him the gear. He willfully ignored our safety protocols. It is 100% his fault."
And in a normal civil court, under normal court law, the employer would win that argument easily. Case closed.
But under the 1923 Act?
Under the 1923 Act, the workman still gets the compensation.
I mean, how does the law justify rewarding a worker who caused his own blinding through sheer willful disobedience?
It's crucial to understand that the law isn't rewarding anyone. The law is looking at the ultimate socioeconomic fallout. If the court denies compensation, what happens the next day?
The family goes broke.
Exactly. The blind worker becomes destitute. His children starve. They drop out of school and become a burden on the state's already strained social assistance programs. The strict liability of the 1923 Act prioritizes the survival of the family over punishing the worker's infraction. The injury happened while he was performing his assigned duty grinding metal, so the nexus holds, regardless of his carelessness.
That is a profound, almost ruthless commitment to social engineering. But surely there is a line. The employer can't be liable for absolutely anything an employee does, no matter how crazy.
There is a line, and it's defined by two concepts: the doctrine of added peril and the explicit exceptions carved out in Section 4A of the Act.
Let's start with added peril. How is that different from just being negligent, like with the safety glasses?
Negligence is doing your assigned job badly or carelessly. Added peril is doing something completely outside the scope of your employment that introduces a new, unauthorized danger.
Give me an example.
Okay, say you are hired as an administrative clerk, and on your lunch break, you decide it would be really fun to try and operate a massive industrial hydraulic press on the factory floor, and you crush your hand.
Yikes.
The employer's not liable. They didn't hire you to operate a press. Your actions didn't just ignore a safety rule. They fundamentally broke the causal chain of your employment. You added a peril that had nothing to do with your job description.
That makes perfect sense. The nexus of employment doesn't cover joyriding on industrial equipment. And what about Section 4A?
Section 4A provides a very specific defense for employers, but with a massive glaring caveat. If an employee is injured due to being intoxicated by drugs or alcohol on the job, or through the willful, deliberate disobedience of an explicit safety rule or the removal of a safety guard, the employer can deny compensation.
So if you show up drunk and break your arm, the employer doesn't pay.
Correct. However, the massive caveat is this: Section 4A only applies to injuries that result in partial or total disablement. If the worker's intoxication or willful disobedience results in their death, the employer is stripped of that defense entirely.
Wait.
They still have to pay full compensation to the dependents.
Wow. So even if a worker gets blackout drunk, ignores 5 warning signs, walks into a restricted zone, and is killed, the employer still pays the widow.
Yes. Because, again, the law's primary objective isn't justice for the deceased worker. It is economic survival for the living dependents who had absolutely no control over the worker's foolishness. It is the ultimate, uncompromising expression of absolute liability.
The morality of that is just staggering to think about. Okay, so we've established the liability. The worker is injured or killed, the nexus is proven, the employer is on the hook. This brings us to the actual mechanics of the payout. How does a judge or a commissioner look at a broken human body and assign a rupee value to it?
It's a pretty grim mathematical calculus, honestly, encoded in Section 4 of the 1923 Act. It removes the emotion from the equation entirely. Compensation isn't based on pain and suffering.
Like it would be in an American lawsuit.
Right. It is strictly based on the loss of earning capacity. The formula uses three primary variables: the employee's monthly wages at the time of the accident, a relevant age factor, and the specific nature of the injury.
Why does age factor into it?
Because it's about projecting lost future earnings. If a 22-year-old worker loses a leg, they have 40 years of lost earning potential ahead of them. If a 62-year-old worker loses a leg right before retirement, their lost future earnings are statistically much smaller. Therefore, the multiplier assigned by the Act is much higher for younger workers, resulting in a larger overall payout.
And the nature of the injury is divided into partial versus total disablement, right?
Yes. Partial disablement means the worker can still participate in the labor market, but their earning capacity is permanently reduced. They lose a thumb, they lose hearing in one ear. The Act actually contains a schedule, a literal list, that assigns a percentage of earning loss to specific amputations or injuries.
Like 10% for a toe, 30% for an eye, that kind of thing.
Exactly. Total disablement, conversely, means the worker is completely incapacitated from any gainful employment whatsoever. Permanent paralysis, total blindness, severe traumatic brain injuries. In these cases, the law treats it as a 100% loss of earning capacity and the compensation is maximized.
So the formula spits out a number. Let's say after running the wages, the age multiplier, and the 100% total disablement factor, the employer owes the family 10 lakh rupees. Here is my question regarding the actual transfer of those funds. Can the owner of the company, knowing they owe this money, just drive over to the grieving family's house, sit down with the widow, hand her a thick envelope of cash, and have her sign a piece of paper saying the matter is settled?
Absolutely, unequivocally not. And if they do, they are breaking the law.
Really?
Yes. This brings us to Section 8 of the Act, which governs the payment of compensation, and it is arguably the most vital anti-exploitation mechanism in the entire statute.
Explain the fear here. Why is a direct cash payment illegal if it gets the money to the family faster?
Think about the power dynamics at play. You have a powerful, wealthy employer, and you have a family that has literally just lost their primary breadwinner. They are grieving, they are likely panicked about how they will buy food next week, and in many historical cases, they might be illiterate.
Extremely vulnerable.
Incredibly vulnerable. If the employer shows up with a briefcase containing 2 lakh rupees in cash and says, "Sign this waiver right now or you get nothing and we'll fight you in court for a decade," the family is highly likely to take the terrible deal just to survive the month.
And the employer saves 8 lakh rupees through coercion.
Exactly. It's extortionate leverage. So Section 8 completely outlaws direct settlements in cases of death, or when a lump sum is owed to a person under a legal disability, like a minor or a woman. The law mandates that the entire compensation amount must be deposited directly with the competent authority, the Workmen's Compensation Commissioner.
So the state acts as the escrow.
The state acts as the protector. The commissioner recalculates the math to ensure the employer isn't shortchanging the family. Then, the commissioner oversees the actual distribution of the funds to the dependents, ensuring the widow gets her proper share, the minor children's shares are protected, and no one is exploited.
What if an employer tries to bypass this anyway?
If an employer ignores this and pays the widow directly, the law treats it as if no payment was made at all.
Oh, wow. So they'd have to pay twice.
Yep. The employer would still owe the full 10 lakh rupees to the commissioner. The only minor exception is that an employer can advance a very small sum capped at 3 months of the worker's wages directly to the family to cover immediate funeral expenses, which is later deducted from the final deposit. But the bulk of the money must go through the state.
And what if the employer just ignores the ruling entirely? They drag their feet, they tie it up in appeals, they refuse to deposit the money with the commissioner. How does the state force compliance?
The state uses a very heavy financial stick. If the employer defaults on the payment for more than 1 month from the date it fell due, the competent authority triggers penalty clauses.
What kind of penalties?
First, They order the employer to pay the arrears. Second, they attach a mandatory interest rate to that amount, punishing the employer for the time value of the delayed money. And third, if the commissioner determines there was no legal justification for the delay, if the employer was just being malicious or stalling to pressure the family, the commissioner can impose a massive punitive penalty, an additional sum up to 50% of the original arrears.
So a 10 lakh rupee debt can very quickly balloon into 15 or 16 lakh rupees if the employer tries to play games.
Exactly. It makes stalling economically irrational for the company.
All right, so we've thoroughly mapped the 1923 Employees Compensation Act. It is a masterpiece of reactive legislation. A catastrophe happens, an arm is severed, a life is lost, and the act swings into motion to force a financial settlement.
It's the ambulance at the bottom of the cliff.
Right. But as the Indian economy matured toward the mid-20th century, a purely reactive system just wasn't enough. I mean, compensating a widow is necessary. But wouldn't it be better to treat the workers' tuberculosis before they die?
Much better.
Wouldn't it be better to provide maternity leave so a pregnant worker doesn't have to operate heavy machinery until the day she goes into labor?
You're hitting on the exact philosophical evolution of the labor movement. You cannot build a healthy, highly productive industrial economy if your workforce is constantly sick, untreated, and working until they collapse. You need a transition from merely compensating disaster to proactively managing workforce health.
And that transition is realized in the immediate aftermath of Indian independence. We move from 1923 to 1948 and the introduction of the Employees State Insurance Act, the ESI Act.
A monumental piece of legislation.
This isn't just a tweak to liability, this is the creation of a massive parallel healthcare state.
The ESI Act of 1948 is arguably one of the most ambitious socioeconomic experiments in the developing world. It takes the concepts of social insurance we discussed earlier, mandatory contributions, pooled risk, and weaponizes them to build a comprehensive safety net.
Let's look at the sheer scale of this. Who does the ESI Act actually apply to?
By default, it applies to non-seasonal factories and establishments employing 10 or more persons. But there is a fascinating caveat that proves the law's intent to protect the most vulnerable workers first.
Which is?
If an establishment is engaged in hazardous or life-threatening occupations, say, handling toxic chemicals or high-voltage manufacturing, the government can notify that the ESI Act applies, even if only one single employee works there.
So the danger level overrides the head count.
Exactly. If it's dangerous, you need the safety net, even if it's a tiny shop.
How does the funding actually work? Because building hospitals and paying doctors isn't cheap.
It works through Section 26, which establishes the Employees State Insurance Fund. This is the financial beating heart of the entire system. Every single month, millions of workers see a small percentage deducted from their paychecks. The employers take that deduction, add their own much larger mandatory contribution, and remit the whole sum into the central ESI fund.
So they're building a war chest.
A multi-billion rupee pool of capital.
And what does that capital buy? Section 46 of the Act outlines 5 major benefits, and I really want to dig into the economics and the reality of each one, because this is where the theory of Social Security hits the pavement of daily life. Benefit number 1 is the medical benefit.
This is the most visible, most heavily utilized pillar of the ESI system. And we aren't just talking about a coupon for a discount at a local pharmacy. Insured workers and their entire dependent families get access to comprehensive, full-spectrum medical care.
We're talking outpatient, inpatient.
Outpatient consultations, specialist care, inpatient hospital stays, complex surgeries, and all necessary medicines.
And this is delivered through their own infrastructure, right? The ESI Corporation literally built its own hospitals.
Yes, a massive network of ESI hospitals and dispensaries across the country, plus tie-ups with private impaneled hospitals for super specialty treatments that they can't do in-house.
That's incredible.
Think about a factory floor worker making a very modest wage. If he needs a double bypass surgery in a purely private healthcare market, that surgery would instantly bankrupt his family for 3 generations.
Yeah, they'd be ruined.
But under the ESI medical benefit, he walks into an impaneled hospital, gets the bypass, and the ESI fund settles the entire bill. 0 out-of-pocket cost. It is a total shield against medical bankruptcy.
Benefit number 2 shifts from medical care to financial survival. Sickness benefit.
Because curing the illness is only half the battle. If a worker gets severe typhoid and needs to spend a month in bed recovering, free medical care is great. But how do they pay their rent that month?
Right. How do they buy groceries if they aren't clocking in?
The sickness benefit provides vital income replacement. If an insured worker is temporarily incapacitated due to illness, and it's certified by an ESI doctor, They receive cash compensation, historically, around 70% of their average daily wages for up to 91 days in a benefit period.
That allows them the economic breathing room to actually heal.
Exactly. It stops the cycle of sick workers dragging themselves to the factory and infecting everyone else because they simply can't afford to take a day off.
That is massive. Now, benefit number 3, maternity benefit. This feels like a cornerstone for gender equity in an industrializing economy.
It is absolutely essential. The maternity benefit ensures that female insured employees receive paid leave surrounding childbirth or miscarriage. An expectant mother can receive 100% of her daily wages for up to 26 weeks.
6 months of full pay. The economics of that are incredible to me. How can a small factory owner afford to pay a worker her full salary for 6 months while she isn't producing anything? I mean, wouldn't that make them stop hiring women?
That is the genius of the social insurance pool. The small factory owner doesn't pay her directly. The factory owner only pays their standard monthly premium into the ESI fund.
Yeah.
When the worker goes on maternity leave, the fund pays her wages, the massive actuarial pool absorbs the cost, socializing the financial burden of reproduction across the entire industrial economy, rather than punishing individual female workers or their direct employers.
It completely removes the economic disincentive for hiring women. That is so smart. Benefit number 4, disablement benefit. Now, clarify this for me. We just spent 20 minutes talking about how the 1923 Act compensates for workplace injuries. Does the ESI disablement benefit replace the 1923 Act?
Yes, where the ESI Act applies, it supersedes the 1923 Act. The worker cannot double dip.
Okay.
If you work in an ESI-covered factory and lose a finger in a machine, you don't sue your employer under the 1923 Act. You claim the disablement benefit directly from the ESI fund. An ESI medical board assesses the percentage of your permanent disability, and the fund pays you a periodical monthly benefit, often for life, based on that percentage.
It shifts the adversarial battle away from worker versus employer to worker claiming from a bureaucratic fund.
Which is much, much less likely to result in the worker being fired for filing a claim against their boss.
Right. And the final benefit, number 5, dependence benefit.
Again, parallel to the 1923 Act, but handled via the ESI pool. If a worker dies from an employment-related injury or occupational disease, the ESI fund steps in. It pays a monthly pension, usually around 90% of the deceased worker's wages distributed among the surviving spouse and dependent children.
So it provides long-term inflation-adjusted security rather than just a one-time lump sum that they might spend or lose.
Exactly. And none of this is optional. The courts have been fierce about enforcing this.
Any specific cases?
The Dalnia Cement Parad LTDV Regional Director ESI Corporation case is a great example. It made it absolutely clear that employers cannot opt out just because they think they offer a better private medical scheme. The statutory mandate is supreme.
But managing a system this colossal, collecting premiums from millions of businesses, running hundreds of hospitals, adjudicating millions of claims, requires a staggering bureaucracy. Who is actually at the wheel?
The ESI Corporation, established under Section 5 of the Act. It is a gargantuan statutory body. It functions almost as an independent corporate entity with perpetual succession.
Who runs it?
It's governed by a central board, which purposefully includes members of parliament to ensure democratic oversight and accountability. Underneath the board, you have a standing committee handling the complex daily administration, and a medical benefit council strictly focused on maintaining the quality of healthcare in the dispensaries.
And day-to-day operations.
The day-to-day execution falls to the principal officers, the Director General, and the Financial Commissioner.
But anytime you have a bureaucracy of that size, and anytime you have an insurance system where real money is on the line, there will be friction, there will be disputes.
Inevitably.
What if an employer creatively reclassifies their workers as independent contractors to dodge paying ESI premiums? Or what if an ESI doctor wrongly assesses a worker's disability at 10% instead of 50%, denying them thousands of rupees in benefits? Where does a worker go to fight that? They can't just march into a regular civil court, right?
Yeah. If they did, the entire Social Security safety net would collapse under the weight of judicial backlog.
Yeah, the courts are already packed.
The Indian civil court system is notoriously slow. A dispute over a sickness benefit could take 15 years to resolve, by which point the worker is long dead. The drafters of the 1948 Act foresaw this bottleneck.
So what was their solution?
Section 48 of the Act, which mandates the creation of specialized employees insurance courts, or EI courts, State governments are required to appoint highly experienced judicial officers, lawyers, or judges with at least 5 years of standing to preside over these specific courts.
It's like a parallel judicial universe.
Exactly. The EI courts have exclusive jurisdiction over all matters relating to the ESI Act. Whether it's a dispute over whether a specific factory falls under the Act, or a fight over the correct rate of contribution, or an employee appealing a denied medical claim, it goes to the EI court.
And civil courts can't touch it.
Regular civil courts are legally barred from entertaining these disputes. This ensures that the cases are heard by judges who understand the complex actuarial nuances of the ESI system, resulting in vastly faster and more accurate adjudications.
It's an incredibly comprehensive closed-loop system of welfare. So we've traced the legal architecture from the brutal realities that birthed the 1923 Compensation Act through the massive healthcare expansion of the 1948 ESI Act. But here is the massive collision course we are currently facing.
The modern economy.
The workplace of 1948, characterized by massive brick factories, punch cards, distinct shifts, and clear lines of command, is rapidly disappearing. How is Indian law adapting to a 21st century economy where you might be coding from a laptop in a cafe, or driving for a rideshare app, or delivering groceries on a scooter? Where do they fit into a law written for textile mills?
They didn't fit at all. For a long time. And that realization sparked the most sweeping, controversial, and massive legal overhaul in the history of Indian labor law, the labor codes of 2020.
To understand the 2020 codes, we have to look at the absolute mess they were trying to clean up. Before 2020, if an employer or a labor union was trying to navigate the law, they weren't just looking at the 1923 Act or the 1948 Act.
Oh, no.
They were staring down a tangled, contradictory labyrinth of 29 different central labor laws. You had the Minimum Wages Act, the Payment of Bonus Act, the Unorganized Workers Social Security Act of 2008. I mean, it was an administrative nightmare.
It was a compliance disaster that was actually hurting workers. Think about the friction this created. If you wanted to start a mid-sized manufacturing business, you had to register under a dozen different acts, maintain 30 different types of physical paper registers, and file returns to half a dozen different inspectors.
Just to run a business.
Right. This multiplicity of laws created a deeply perverse incentive. It made formalizing a business so legally perilous and administratively expensive that millions of employers simply chose to stay in the shadow economy, the informal sector.
And if the business is off the books, the workers get absolutely zero protections. No ESI, no compensation, no safety gear.
Precisely. The complexity of the law became the very barrier preventing the expansion of the safety net. So the government initiated a massive rationalization project. The goal was to consolidate, simplify, and modernize.
What did they do?
They took those 29 disparate laws and collapsed them into 4 comprehensive labor codes: the Code on Wages, the Industrial Relations Code, the Occupational Safety, Health, and Working Conditions Code, and the one that rewrites our entire discussion today, the Code on Social Security 2020.
The sheer scale of the consolidation is staggering when you look at the numbers. We go from 29 acts generating 1,436 separate, often contradictory rules, down to just 351 streamlined rules.
A massive reduction in red tape.
Instead of an HR department filling out 31 different paper returns, there is a single electronic portal. Multiple licenses are replaced by one unified registration. And controversially, the codes decriminalize several minor technical offenses, replacing the threat of a factory owner being thrown in jail for a paperwork error with a system of monetary fines.
The government championed this as promoting the ease of doing business.
But whenever we hear ease of doing business, the immediate fear is that it's code for stripping away worker protections to please corporations. Both sides of the political aisle have argued about this endlessly. But looking strictly at the source material, does the Code on Social Security actually dilute the safety net we just spent an hour discussing?
If you look specifically at the text of the Code on Social Security 2020, its explicitly stated objective is the opposite. It seeks to vastly expand the perimeter of the safety net. The new code subsumes the EPF Act, the ESI Act, the Maternity Benefit Act, and the 1923 Compensation Act into one unified framework.
So it doesn't erase them?
It doesn't erase them. It modernizes their administration. But the absolute paradigm shift, the game changer that makes this code historic, is how it handles the informal economy.
The unorganized sector.
Yes. For decades, laws like the ESI Act only applied to the organized sector factories with 10 or more workers. But the vast overwhelming majority of India's workforce, street vendors, agricultural laborers, domestic workers, construction casuals, operate in the unorganized sector.
And they were just locked out of the safety net.
Completely locked out.
Yeah.
The 2020 code explicitly mandates the extension of Social Security schemes to these unorganized workers.
That is a colossal undertaking. But the code goes even further than traditional unorganized labor. It introduces entirely new legal vocabulary to deal with the digital age. For the first time in Indian legal history, the law formally recognizes and defines platform workers and gig workers.
This is the absolute legal frontier right now. The code recognizes that a person driving for Uber or delivering food for Zomato isn't a traditional employee clocking into a factory, but they also aren't truly independent business owners. They're an entirely new class of labor.
And Section 114 addresses them.
Yes, Section 114 of the new code explicitly mandates that the central government must frame suitable Social Security schemes specifically tailored for gig and platform workers.
What does that actually look like? Are we talking about giving an Uber driver ESI hospital access?
The code lists the exact matters these new schemes must cover: life and disability cover, accident insurance, health and maternity benefits, and old age protection. It even mandates provisions for creche facilities.
But who pays for it? If they aren't traditional employees, you can't force the traditional employer's employee contribution model.
The funding model is ingenious. The code states that the schemes will be funded by contributions from the aggregators, the massive tech companies whose platforms rely on this labor, along with potential central and state government funding, and potentially a nominal contribution from the gig worker themselves.
Oh, wow.
It is an attempt to force the algorithmic economy to internalize the cost of the human fragility it relies upon, just as the 1923 Act forced the factory owners to internalize the cost of broken limbs.
It is a phenomenal attempt to build a 1948-style safety net for a 2020s digital workforce. And that brings us to the end of an incredible legal timeline. For you listening, whether you're studying for that LLB exam or just trying to make sense of the modern economy, look at the immense distance we've covered today.
That's a long journey from 1923.
We started in a world where an injured worker was left to rely on the charity of a joint family or face absolute starvation. We unpacked the revolutionary sledgehammer of the 1923 Compensation Act, where the law finally declared that strict liability must apply, that fault doesn't matter, only the causal nexus of employment matters.
Right.
We waded into the massive proactive healthcare infrastructure of the 1948 ESI Act, seeing how pooled risk can fund surgeries and 6 months of maternity leave. And finally, we looked at the massive 2020 consolidation as the state desperately tries to stretch that safety net to catch the modern gig worker.
It is a story of constant, difficult adaptation. The law is always playing catch-up with the economy. And as we look at those 2020 codes, there's the lingering, almost philosophical question that the next generation of lawyers and judges are going to have to answer.
What's that?
Well, for exactly 100 years, the entire architecture of Social Security has rested on the phrase from the 1923 Act, arising out of and in the course of employment. That concept was built around physical factory gates, set shifts, and a human manager you could point to.
But in the gig economy, those boundaries just evaporate.
Completely. When a delivery driver's workplace is their personal smartphone and the entire city street grid, when their manager is an opaque algorithmic app, and when their commute is endless and nonlinear, how will future courts define the nexus of employment?
That's a great point.
If a gig worker is logged into the app, sitting in a parking lot waiting for a ride request, and gets hit by a car, are they in the course of employment? They weren't performing a task, but they were available for capital to use them.
We have modernized the text of the statutes, but the courts are about to face an entirely new, deeply existential battle over what it actually means to be at work.
Exactly. The physical gates are gone.
The boundaries of the factory have become invisible, but the physical risks to the human body are as real as they were in 1923. It's a fascinating legal horizon. Thank you for joining this deep dive into the architecture of our social safety nets. Keep questioning the structures around you, keep looking closely at the rules that govern our labor, and we will see you next time.